So 24 states are now stepping up and demanding that Congress take action and pass a long-awaited bill aimed at establishing national concealed carry reciprocity. Let's break down what just happened. A new bill has officially been introduced in Congress, H.R. 38, also known as the Constitutional Concealed Carry Reciprocity Act. This legislation is gaining attention following recent remarks from former President Trump, who made it clear that if he were back in office and this bill reached his desk, he would sign it into law without hesitation. Now, Congress is making moves to fulfill that promise. H.R. 38 has already passed through a House committee and is on its way to the House floor for a full vote. The main goal of this bill is simple: to remove the invisible barriers that prevent law-abiding Americans from exercising their Second Amendment rights when crossing state lines. Right now, if you have a concealed carry permit in one state, it might be completely invalid in another. That patchwork system leaves responsible citizens vulnerable to criminal charges just for traveling. Even though the bill made early progress, it's currently stalled, and that's where the pressure is ramping up. 24 state attorneys general have signed a formal letter demanding that the House move forward with a vote and finally pass this bill. Under this proposed bill, if you're visiting another state and you end up interacting with law enforcement, whether you're pulled over or stopped for any other reason, and they discover you're carrying a concealed firearm, they cannot arrest, detain, or charge you as long as you have either a valid concealed carry permit from your home state or a state-issued ID if you're from a constitutional carry state. Although the bill successfully passed through the committee hearing stage, momentum has since slowed. It's currently stalled, awaiting a vote in the House. That's why 24 state attorneys general have stepped in, demanding that Congress act. They're urging the House to hold a vote and advance the bill to the Senate. In their joint demand letter, the attorneys general wrote, "We, the undersigned attorneys general of 24 states, urge Congress to pass H.R. 38. Our perspective comes from our role as the chief legal officers of our states. States that either recognize the right of law-abiding citizens to carry concealed handguns without a permit or grant full recognition to concealed carry permits issued by other states. Simply put, we know from direct experience that recognizing a broad right of concealed carry among responsible citizens promotes public safety and protects the fundamental liberties of the people we serve. It is with these citizens in mind that we strongly encourage Congress to pass H.R. 38. The letter also addresses several common misconceptions about the bill. First, it emphasizes that H.R. 38 only applies to law-abiding gun owners. It explicitly excludes anyone who is prohibited under federal law from possessing or transporting a firearm. This includes individuals convicted of felonies or certain misdemeanors that are punishable by more than 2 years in prison. Critics of the bill have claimed that it infringes on states' rights. But the attorneys general argue this is misleading. The bill does not override or alter any state's concealed carry laws. States will still have full authority to set their own requirements for issuing concealed carry permits, restrict where firearms can be carried on publicly owned property, create and enforce rules regarding how firearms are displayed, brandished, discharged, or used in public, define the conditions under which defensive force is legally permitted. Importantly, private property owners also retain the right to decide whether or not to allow firearms on their premises. Nothing in the bill changes that. Another concern raised by opponents is that this legislation would somehow prevent police officers from doing their jobs. But according to the attorneys general, this is not true. In fact, permitless carry is already the law in the majority of U.S. states, and law enforcement continues to operate without issue in those areas. The bill explicitly affirms that police officers retain the authority to conduct lawful investigative stops when they encounter someone carrying a concealed firearm. These stops must still follow legal standards like those outlined in the Terry v. Ohio Supreme Court decision, allowing officers to determine whether the individual is carrying lawfully and whether they meet the criteria set by the Act. If a person is found to be carrying a firearm illegally, or if their actions violate state law in any way, those laws remain fully enforceable. Any criminal activity connected to firearm possession would still be subject to prosecution under existing state law. One of the main criticisms aimed at H.R. 38 is that it would force states with strict permitting requirements to recognize concealed carry holders from states with less restrictive standards. But what that really reveals is that some states, despite clear rulings from the U.S. Supreme Court, continue to impose costly, complicated, and intentionally burdensome processes in order to discourage lawful citizens from exercising their constitutional rights. The reality is that making it harder to get a permit does not mean only the safest individuals are allowed to carry. In fact, there is significant evidence showing that concealed carry permit holders are more law-abiding than the general population. And to date, there is no credible evidence that any one state's permit process is more effective at filtering out dangerous individuals than another, especially when it comes to the standards considered under H.R. 38. Take New York, for example. For years, applicants had to prove an extraordinary need for self-defense in order to be granted a license. This requirement had nothing to do with selecting the most responsible applicants. Instead, it created a system that fostered corruption, with New York City licensing officials eventually convicted of accepting bribes in exchange for permits, even from applicants who failed to meet the legal criteria. In Los Angeles, the barriers are different but just as problematic. There, applicants face excessive fees and wait times that can stretch over a year. As a result, the Department of Justice launched a civil rights investigation into the city's licensing practices. Yet even with those restrictions in place, it hasn't led to safer outcomes. It simply made it harder for law-abiding people to exercise their rights. The truth is, criminals don't wait for permission to carry firearms. This bill isn't designed for them. It's intended for responsible citizens who follow the law. People who may one day find themselves in a situation where they need to defend themselves or their loved ones when law enforcement can't respond in time. Concealed carry is a constitutionally protected right, and when exercised lawfully, it provides real public safety benefits. But unfortunately, many law-abiding gun owners are still being threatened with arrest, prosecution, and even mandatory prison time for violating technicalities in gun laws that are out of step with the vast majority of other states. These individuals aren't criminals. They're citizens who, in many cases, are doing something that would be completely legal in almost every other part of the country. Yet they face severe consequences simply because they crossed into the wrong jurisdiction. This kind of legal patchwork is not only unjust, it's unsustainable. That's why Congress has a responsibility to step in and protect the rights of these individuals. The 24 attorneys general who signed this letter are standing up against the false narratives that have been used to stall this bill. They're calling on the House to take action now and pass H.R. 38. With Republicans currently in control of Congress and former President Trump stating he would sign this legislation into law, there's a real opportunity here to finally move this bill forward. But the next step is clear. The House must vote. Once it passes the House, the focus will shift to the Senate, where pressure will need to be applied to ensure this bill continues to move. So that's where things stand right now with the National Concealed Carry Reciprocity effort. You now have 24 states standing together, calling on Congress to act, and calling on the House to stop delaying and move this legislation forward. We'll be watching closely to see how this develops. As always, thank you for tuning in. Don't forget to like, leave your thoughts in the comments, and subscribe for future updates.